Hi there, and thank you for tuning into this very quick webinar on the upcoming changes to CPR Part 25. My name is Ali Tabari. I'm one of the barristers here at St Philip's Chambers. A lot of my work involves getting in pretty urgent injunctions for the fraud and insolvency type of work that I do. So it's very relevant to me, and hopefully this will be a good guide to what's coming up for everyone next Monday. So as you can see from the title of the talk, it's just the essentials. There's no substitute for going away and reading the new provisions yourselves. What I'm going to try and do in this talk is I'll try and cover what the changes do, what the changes are. I'm going to focus a little bit on model orders because they are quite a substantial change and an important one for all practitioners to know about. And then just a few things to remember at the end. So if you haven't got much time, just skip to the end of the video and it will tell you. So what do the changes cover? Brand new CPR 25 takes out all of what was there in Part 25, removes it and replaces it with something altogether different. What it also does is it takes away practice directions A and B that you'll currently find in the rules. It doesn't do away with their content. What it does is it subsumes those into the new Part 25, as we'll go on to in just a moment. Where you'll find the wording, if you want to have a look at it before it comes in on Monday, is the very snappily titled Civil Procedure Brackets Amendment Rules 2025, and you find it in the schedule at the end, and it's got the whole of the new Part 25 there, and it's effective from the 6th of April. So any work that you do up until this weekend is covered by the current 25. Anything from Monday onwards, it is the new Part 25. So just a really quick overview of where the old rules are in the new rules. You can see there that under 25.6 to 25.9 in its current form, interim payments, they're all there in the same form. They've just been moved and they incorporate practice direction B. Everything in terms of security for costs is exactly the same in terms of its content. It's just that it's moved again to point 26 to point 29. And what's come in is from 25.5 to 25.19, a whole bunch of new provisions there on interim injunctions. And what it does is it incorporates practice direction A. And then, as you can see from the bottom, the model orders that are replaced by the new model orders. And as I said before, we'll come on in just a few moments to a bit more detail about those. So a few changes substantively to CPR 25, which is worth flagging up at this stage. For those of you who've ever dealt with an imaging order, there is now the express power within the rules to make that imaging order under Part 25.1 sub I. In some ways, it's just more of a form change rather than a substance change, because the power to make an imaging order was in the court's inherent discretion already there, but it's just now it's coming up to the modern age and it's had an express provision inserted now. This is an interesting one for you and all the barristers that you're going to be using for these type of hearings. Draft orders for urgent hearings are now required 2 hours before the hearing. So whereas sometimes you'd be rushing into court with a printed out copy of a draft order in your hand ready to hand up, the rules now do say that as a starting point 2 hours beforehand. I imagine as time goes on there'll be a bit of flex about this depending on the type of case. But we'll come on to the reasons why these draft orders are required 2 hours beforehand when we look at model orders. Telephone hearings, I always imagine a High Court judge sat in their pyjamas at 10 p.m. on a Saturday, getting a call for an urgent injunction to be heard there and there by telephone, dragging all of us into the 21st century. Telephone hearings are no longer provided for in the rules, which I think is probably going to be a relief for the High Court judges as much as anyone else. But I think the point of all of this is to try and drag the procedure and the current form of the rules into the modern age. Telephone hearings, for anyone who's had to deal with them in post-COVID times, they are generally pretty undesirable. So those are the main substantive changes, and we've gone through where they're now located in the rules. But let's have a look at these model orders, because I think these represent quite a substantial change, things for practitioners to know. Now, generally speaking, when there's new rules, people like me sit and moan about it and say, oh, well, it's not going to have the desired effect. It's going to make things more difficult. If anyone remembers talks on disclosure, new witness statements, cost we all thought it was a pretty miserable idea. But actually, for me, I think these changes to the rules are very welcome. Changes to the model orders are good. What they do is they benefit a good practitioner. They benefit people who do things properly. And what they are meant to do, I think, is to try and ward off all of the heat and light that comes from injunctions and so on obtained by parties not quite getting it right, leading judges down a garden path and meaning that the return date is just an absolute car crash. So there's a new front page on the model orders, usually not that important, but it is important here because you can see right at the bottom where the asterisk is, the model order includes footnotes provided for guidance. They're not part of the order, but when you're submitting the draft order to the court, 2 copies, one in Word with all of the footnotes in it, and one without the footnotes and so on. And we'll come on to what the significance of all of these footnotes are and why the court would want them to be submitted in duplicate beforehand. There are lots of footnotes, as I say, tackling issues which frequently arise. In the end, I think what's happened here is that judges hearing these hearings and these applications have taken the view that there are common issues that arise over and over again that could just be avoided if there was a neutral but comprehensive setting out of what's expected right from the outset, so that the judges know what they're tackling and the practitioners know what they have to deal with as well. Now, some of these footnotes are, I suppose, for information only, the kind of things that you'd maybe panic about first time you do it, but then you wouldn't. So, for example, if you've ever had the position of trying to work out whether the judge that you're in front of has the jurisdiction to actually grant the order you're asking for, footnote 1 in the freezing order sets it out nicely for you. It tells you what a penal notice is. You'll probably know it, the respondent might not, but it's important that it's not part of the order there. Talking about the timing of return dates. Again, sometimes inexperienced judges and practitioners will get this wrong. In the commercial court, it says normally on a Friday for the return date. Apparently there is law outside the M25, and I suppose you'll just have to deal with the local listing practice in those other spots that aren't London. You can see here that these rules were obviously drafted just that little while ago. You've got here in the model freezing order talking about the amount that's going to be frozen and talking about it being the value of the claim for which the applicant has a good arguable case. You'll obviously all be aware doing this type of work that that test is slightly different now. It's whether there is a serious question to be tried, and that's the Court of Appeal decision in Dos Santos and Unitel at the back end of last year. But I'm sure that's an amendment that can be made in due course. Now, quite a lot of these footnotes, what they do is they take the case law and the already established principles that we know about doing this type of work, and they put them in the footnotes without necessarily naming them. So, for example, if you have a freezing order here, you can see footnote 7. It talks about the respondent being regarded as having power to deal with assets if a third party holds or controls them in accordance with the respondent's instructions. Well, as I say, for the good practitioner, you look at it and you say that's a CHABRA order potentially that's being made there. It's just not phrased as such, but it flags up the possibility that it might take on that nature. Again, the same thing here, still on the model freezing order. If you look at subparagraph 8, it talks about a business of the respondent which is carried on under a trading or business name being distinct from the business of a company with a separate legal personality. Well, again, we all know that's the Salomon and Salomon principle. It's not named as such, but these are things that judges have to take into account. Another example, paragraph 10 here, costs of legal advice and representation, and whether or not any sums accepted from the freezing order are within the ordinary and proper course of business. Well, we all know that as the Angel Bell exception. But again, it's there for those who might not necessarily know it. And I'll come back a little bit later on to dealing with skeleton arguments and the effect that these footnotes could have on it, which I think is quite a helpful one. Those were some of the footnotes in the freezing order. Just going to have a look at the proprietary injunction. As I said before, there's no substitute for just reading these model orders, reading the new rules. They are all pretty widely available on the internet. but it is worth having a look at, for example, this model proprietary injunction, talking about those exceptions to the proprietary injunction in respect of ordinary living expenses, legal representation, advice, disposing of assets in the ordinary course of business, and so on. These numbers can sometimes be quite contentious between the parties, and you often find on a return date that there is quite a bun fight about what those numbers ought to be. But you can see there that the footnotes are pretty helpful in terms of trying to guide perhaps the inexperienced judge or maybe an inexperienced applicant to try and work out what those numbers should look like. So you can see there again these cases that the principles are there, but the cases aren't named. Paragraph 12 there, court deciding whether in a proprietary claim it ought to make any allowance for monies to be spent. Because, of course, on a proprietary case, it's not the respondent's money, we would say, as the applicants. It's our money. So there has to be a bit of a careful, circumspect approach taken to whether or not an exception like that is allowed. Provision of information in proprietary injunctions. Obviously, we know that often what happens, particularly in large fraud cases, is that on a first order, all you know is that you've got your first level of fraudster or associates whose assets need to be frozen. But sometimes there's a dissipation that's already occurred, and you're trying to find out where the third parties are who received all of these funds. Often what this leads you to do is to make either a banker's trust order or Norwich Pharmacal order application against parties who are innocently mixed up in the wrongdoing, such as banks. Generally speaking, one of the things that you have to overcome in order to make good one of those applications is to say, well, it's a bit of a last resort, but we won't be able to get it out of the respondent themselves. There's a bit of additional wording here in the model proprietary injunction here that says that when information is being provided by the respondent about their assets and so on, the information that has to be included is things like the name and contact details of anyone to whom any proprietary assets have been transferred, and the account number and the sort code of any bank account to which any transfer was made. So again, it's helpful for the good applicant because it means that if you do need to make a BTO or an MPO application of it later on, you've got the foundation of it here, because you could say, well, either we've had the information but some's missing, or look, the respondent's been ordered to give the information but just hasn't done. So it's meant to be helpful and it's meant to be streamlining. And you can see there that there are some words of warning here for the judges, really, and for the applicants, about saying careful consideration has to be given to what period for the provision of information is realistic. There's nothing worse than being on a respondent's side and a client coming to you and saying, right, I've got this letter with a scary order behind it that tells me I've got 3 days to come up with a whole list of all of my assets that are worth £1,000 or more. And these footnotes are there to make sure that the judges actually think about whether this is realistic, and it hopefully makes the applicant stop and think what's realistic as well. Moving on to the final of the new model orders that I just want to discuss, model search and imaging orders. For those of you who've had the misfortune to try and get imaging orders in the past using the model order, you'll know that actually whilst the model order for search orders, as currently is pretty good in Practice Direction 25A, the one for imaging orders was just an absolute nightmare. It wasn't in Practice Direction, it was in Form N608. It was not a helpful document to work from. It was really inconsistent with the other model orders. You had to take it and mangle it and turn it into something a bit more useful rather than just using it as is. So a really welcome development is that the model orders now have provisions within the same document for search and imaging orders, because sometimes you need both, sometimes you just need one, and you can delete as appropriate. If you remember, the respondent always has the right to withhold the inspection of documents on grounds of privilege against self-incrimination, but there was an exception to this, which is that if their conduct might have constituted an offence under the Fraud Act 2006, then they didn't have that right to withhold. Well, that's now gone, so it makes it nice and simple. The right to withhold remains across the board. This I always find it's quite an amusing one. In the previous search orders and imaging orders, there was always a restriction on the respondents, on the applicant's representatives from touching or searching the computers and so on, presumably on the assumption that we don't know how to work with computers. Bit strange, but anyway, 21st century now, the presumption's flipped, and we are now allowed to touch other people's computers on the assumption that we do actually know what we're doing. So there we are. There are a few passages in the new model orders and the new rules which put greater responsibility on the applicants and their representatives. The first is that the applicant now must provide a copy of the order to anyone who's notified and pay reasonable costs of third parties arising from the order. I suppose that comes from the fact that imaging orders are becoming more common than search orders. And when you're dealing with imaging orders, sometimes you have, for example, servers on third-party sites and so on. Previously, there was a little lacuna in the rules where you didn't actually have the express obligation to give a copy of the order to anyone affected by it, but there we are. Now you do, and to pay their costs arising. For anyone who's dealt with being a supervising solicitor, obviously it's a really onerous task, but now the supervising solicitor is obliged under paragraph 10 of the model order to explain to the respondent its right to withhold inspection on grounds of privilege against self-incrimination. Previously, it was only in respect of search orders, but now we have it for imaging orders as well. As you can see, bringing it up to speed, making it consistent, which is good. Previously, the independent computer expert wasn't automatically able to remove any item to image it. Now they can do, but they have to return it within 2 days. So you have to think carefully about whether or not it's helpful to take a device or a computer or so on off-site if you think that you can't deal with it in 48 hours. Remember, the last imaging order I did took apparently 7 days to download everything. So it was a pretty tricky ask for everyone involved. So final bits then, things to remember. If nothing else that you get from this talk, remember to get a duplicate copy of the draft order to the judge at least a couple of hours before the hearing. I would say when you then come to deal with the orders themselves, and in particular the search and imaging orders, which has, as I say, both the search and the imaging provisions in there, and you might not need both. Try not to delete paragraphs entirely, maybe just leave the square brackets blank. That's probably easier to deal with. Again, anyone who's ever turned up to a return date and has to make submissions that sound like, Judge, if you could look at paragraph 25 used to be 27, and now look at paragraph 30 used to be 28. It's a right pain, and we can definitely do it better by just leaving them blank. I think what it can do is it can reduce the length of skeleton arguments and so on to be able to rely on these new orders, because, as we've seen, when you go through the footnotes, it deals with the kind of things that you would need to deal with in your skeleton argument anyway. So it might mean that obviously you'd have to set out the facts as fully as you can. You'd have to set out the full and frank disclosure as fully as you can. You'd have to address the test, of course, but that bit you might just be able to deal with in a little bit more abbreviated fashion with reference to the footnotes in the model orders. So it could just be to say footnote 10, submission this, footnote 11, submission this, and then do some footnotes within your own skeleton argument to deal with the relevant case law as necessary. But I think what it does is it makes it just that little bit more methodical and a bit easier to follow for the judge, which is good. And I think what that could do is, from an applicant point of view, it could actually improve your position in respect of freezing orders and the cost orders that follow them, because as you'll know from the broad idea case and recently again in Dos Santos, the higher courts are now saying, well, if we're talking about freezing orders and the costs that arise from them, they are standalone issues. It's not like an American Cyanamid cost order where you just reserve it off to the trial and see what happens. Actually, the freezing order is a thing in a. So from an applicant's point of view, you can say we've dealt with everything properly as per the model order and ticked it off to your satisfaction. Then what it does is it reduces the force of any questions being raised in the return date. And if you can show that really everything was in apple pie order from the beginning and you've dealt with it as you should have done, I think it makes it probably a stronger case for getting your costs, particularly from judges who might still be a little bit reluctant to grant them. So there we are. Hopefully that's been helpful. As I say, take a look online for the new rules and the new model orders. But otherwise, happy injuncting. and hopefully see you on the other side of one of them or on the same side.